Well, hello, good morning. Welcome to another Sunday morning coffee with Dr. Childress. Today I'm going to be obviously talking about the California Board of Psychology hearing coming up on December 29th through the 31st. That's going to be the focus of my attention through the month of December and likely beyond. I have a strong suspicion that this is going to be a landmark case having to do with institutional capture, regulatory capture, Stigler, and institutional betrayal trauma. This is a classic example of both in the family courts. And it's child abuse and undiagnosed child abuse. And the AI estimates is like hundreds of thousands of victims at this point, now adult children and parents, and then ongoing in the family courts, like daily is the undiagnosed child abuse and spousal abuse, and incompetence violations of 2.01 boundaries of competence, 2.04 established knowledge, 9.01 bases for assessment, 3.04 avoiding harm, and all three principles of the Belmont report having to do with experiments on human subjects. So this is going to, I think, get a lot of attention over the next 40 years or something. It'll extend beyond my time. Just by the way, I'm going to turn 71 this year in March, and my estimated longevity, based on my family history of two older brothers and my dad, they all died in their early 70s, and so I'm estimating age 74 plus or minus 2. So potentially I'm out of here in another year or two. And so I'm documenting into the record my duty to protect. I've been in the family courts for 15 years, holding a duty to protect and mandatory 1.05 obligations. That's why I'm in the family courts. I have early childhood and attachment. And I'm more interested in AI psychology at this point. But the reason I'm here is because it's undiagnosed and untreated child abuse and spousal abuse, savage spousal abuse. Oh my goodness. So let's talk about what's going on in the California case. And one of the reasons I'm talking about it is that this has broader public interest concerns relative to regulatory agencies, relative to legislative oversight, relative to institutional betrayal trauma for hundreds of thousands of parents. So I am being fully transparent because I'm in the whistleblower role, and it is within a situation of institutional capture, Stigler, regulatory capture. The institutions will seek to suppress the whistleblower to avoid their own embarrassment and things. And you can think of the Catholic Church and the sex scandal about how they were moving pedophile priests around from parish to parish. That's what the institutions try to do, is diminish that. So to begin with, just to orient, I have multiple domains of not only competence, but expertise, attachment, early childhood mental health, delusional thought disorders, 12 years of training to the top professionals in that, Ventura and Lukoff, and the authors of the brief psychiatric rating scale. So I'm one of the best trained people on the planet in diagnosing delusions, child abuse and complex trauma. I was a clinical director for University Assessment and Treatment Center for kids 0 to 5 in foster care. And then the one I want to point out is the IRB and Belmont report, and then the community psychology is what allows me to see the institutional capture and institutional betrayal trauma. But that one, the IRB and Belmont report, is I was an invited consultant to OPRR, the Office of Protection from Research Risk, now currently OHRP, the Office of Human Research Protections, who oversee all the IRBs, institutional review boards at all the universities. And they were developing policies for all the IRB and review of research stuff. And so they held this conference with the American Association for the Advancement of Science and invited me back. And so I was like a consultant to them on developing guidelines for IRBs. So I know the Belmont report, and I know requirements for IRB. Plus, I was working with major NIMH researchers and things. So I know what's supposed to be happening, and it's not happening. So one of the classic features of abuse pathology, now remember, that's my pathology. I come out of child abuse and foster care. So one of the classic features of abuse pathology is it isolates its victims from reporting and rescue. And you can think about that like with the spousal abuse victim, how that abusive husband, let's say, just isolates that woman from her friends, from other contacts, and really gets very controlling of her contact. He's isolating her from reporting and rescue. The sex abuse pedophile who will isolate that child from reporting and rescue to everybody else. Elder abuse, you isolate the elder. So that isolation is a classic feature of abuse pathology. And that's exactly what's going on in the family courts with the parents and children. They've been isolated and are being denied standard healthcare services of diagnosis and treatment using the DSM-5. And while this unregulated experiment is being conducted on them regarding this quasi-judicial role for doctors and an experimental assessment procedure called a forensic custody evaluation, and it's being conducted on them without IRB review, which is problematic and a violation of 8.01 of the APA Ethics Code. So without IRB review, and in violation of all three principles of the Belmont report that cover it needs to be a stopped moratorium on forensic custody evaluations until we get outside review. New York Blue Ribbon Commission calls them dangerous, harmful to children, potentially disastrous consequences. Votes 11-9 to get rid of them. So, yeah, it needs review, and why the licensing boards are allowing this. All 50 states are allowing this dangerous, harmful, potentially disastrous experiment on their citizens when they know it's dangerous without reviewing it and getting outside review. I have no idea. I suspect that sets up well for a class action lawsuit down the road. So, but I'm a psychologist, not an attorney, and that's not necessarily my concern, other than I recognize that that's in the public interest. So I am establishing the documentation trail for that. I tried to discharge my duty to protect to the California Board of Psychology. They refused to accept the discharge, so therefore I continue to carry the discharge of duty to protect because they are advocating for the pseudoscience of parental alienation rather than focused on the protection of the citizens of California. And so that, I think, deserves legislative oversight at this point. They're arguing in their motion in Lamine that the APA Ethics Code is irrelevant, the DSM-5 established knowledge is irrelevant, and even that truth is irrelevant. And so we really need to get legislative oversight into the licensing boards relative to what's happening in the family courts. So I put up on my media site, you'll see, and so if you go to drchildressconsulting.com and click around, and any parent or attorney one will get you into the media information as well as legislative information and things and all the documents. But the media information page currently has a press kit for Dr. Childress regarding the Board of Psychology. So if anybody wants to get a hold of media, that gives you a format that you may want to think about contacting them about. I think this is a broader public interest regarding oversight, regarding child abuse in the family courts, and why all the regulatory agencies and APA is doing nothing, and AFCC is promoting this fabricated pathology, and there's no diagnosis. The thing is, we talk about this for just a second. The thing is, not only are the forensic custody evaluators experimenting on the parents and children in the family courts with this experimental quasi-judicial role of advising the court, an experimental assessment procedure, forensic, They are withholding standard clinical care of diagnosis and treatment. IRB would never allow you to withhold standard of care and offer only the experimental treatment, and has been going on for 40 years. So there's I think a major scandal coming with hundreds of thousands of abuse victims who are now grown up, and we need to get back out to them. We have now adult children who are still disoriented and still lack bonding, and they think it maybe was their fault and what happened. And we've got the targeted parents who had their children ripped away from them and traumatic grief, and they're wondering, what did I do wrong? And this unresolved grief. We need to get therapy services into both of those. And for institutional capture, that's Freud, F-R-E-Y-D, for institutional capture, the treatment for that is it's called institutional courage. So the institutions have to acknowledge what happened, and that frees the victims from their own self-blame. And the first thing we tell abused children is, it's not your fault. You did nothing wrong. Bad people did bad things to you. We're going to make them stop. And so that's what the institutions need to step up and say to the now adult children and parents, you did nothing wrong. Okay, it wasn't your fault. It wasn't even the fault of the pathological parent. They're damaged. They're injured from their own childhood experiences. It's the fault of the people who should have protected you. It's our fault. And free them from that blame and self identity issues and loss of attachment bondings and all those sorts of things, and get in there and treat the consequences of 40 years of unregulated experimentation on parents and children in the family courts. So that's up there. And then you can see, as you go down, you see the settlement proposal, and you'll see a couple of the motions in Lamine that are interesting. The settlement counter proposal, to talk about that for a second, that's where I attempted to discharge my duty to protect to the California Board of Psychology, and they just simply decline it, the discharge. So that means I have no place to discharge my duty to protect. So that means I still carry it until I'm able to discharge it. So I will be attempting to discharge my duty to protect at the California Board of Psychology hearing, 3 days, public access, media, legislative aides can look at that and watch it. And it'll produce a transcript and all the documents that at least I submitted, and they'll object to some, but at least I'll have them on record. And so that settlement counter proposal describes what needs to happen: moratorium on forensic custody evaluation, remediation of 2.01 competence for professionals in the family courts. I would suggest an AI review of all the vita of forensic custody evaluators in California, across the nation. Any state can do that: Michigan, Pennsylvania, Florida. Just ask for the vita, run it through an AI. Are they competent in attachment? Are they competent in delusional thought disorders, family systems, child abuse and complex trauma? And just get a sense. Just look at what the competence standard. You're the board, you're the licensing board, supposed to be protecting your citizens. Just look. You have the New York Blue Ribbon Commission and somebody with 15 years of experience in the family courts telling you, please look. Can we say institutional and regulatory capture? So yeah. So now, what's the current situation? So I posted over to the document section of my website all the documents. So we have my defense document. My formal defense document is now up there. I submitted that last week. And we have the 4 motions in Lamine and oppositions. And it's that opposition, the complainant's opposition to respondent's motion in Lamine, that contains their argument that the APA ethics code is irrelevant in evaluating the psychologist, that the DSM-5 is irrelevant for establishing 2.04 standards, and that truth is irrelevant. Now, my AI, when I talk about that, says that's a due process violation. So if it's granted, there's probably grounds for appeal, which would extend it for another 18 months. So we may get this going on for a period of time. And since I'm self-representing, I'm working with an AI and learning the legal system and stuff. So, okay, I'm trying to discharge my duty to protect, and that's a clinical duty to protect and an ethical standard, 1.05. So, and you can upload these to your AI. Just upload them to your AI and you can talk about what they are. So you don't actually have to read them line for line unless you want to. Then here's all the exhibits. And that's what I want to talk about this morning through the coffee, is just identify what they are. So Respondents Exhibit 1 is in 2020, I consulted with an ethics expert. He's Dr. Strum. He's a PhD in psychology and an attorney, JD. And he consults on ethical issues for mental health professionals. And so I contacted him because I wanted to consult on 1.04 and the institutional capture things. So that's the email to him. And it has a couple of links to blog posts and things about the forensic custody evaluations and stuff. And so that's clearly what I'm consulting with him about. And then his website materials indicating he consults on ethical issues. And so that's what you're supposed to do. Okay, I've done all the things that a psychologist is supposed to do, and I'm under threat by the California Licensing Board. So when there's an ethical concern, I consulted on it, and he agreed that I have 1.04 and 1.05 obligations, and the APA Ethics Code. Let me talk about that. APA Ethics Code is mandatory. It's not optional. And so all the 2.01 violations in forensic, that's not optional. And my 1.05 is not optional. I have to do it. And then I'm getting under threat from the California Board of Psychology for following my mandatory guidelines. I'm trying to discharge my duty to protect. The whole system is upside down and inverted. So, and then those are both having to do with their motion in Lamine. And then Respondents Exhibit 3 and 4 have to do with my respondent's motion in Lamine. And the first one is about the mental status exam of thought and perception. That's the standard. So the moment we go back to applying the DSM-5 in the delusional disorder, there's an assessment, mental status exam for thought and perception. We can diagnose the delusion. It's an affirmative diagnosis. You pop it out in your session if you know how to do a mental status exam, which I do because I've been trained for 12 years in that. So by withholding the diagnosis and by putting up these fabricated pathologies like parent-child contact problems or parental alienation or all these fabricated knowledge, rather than applying the DSM-5, you're denying the diagnosis when it solves it immediately the moment we apply the DSM-5. But neither the forensic custody evaluations or these self-proclaimed experts in parental alienation are applying the DSM-5. It's already in the DSM. So then, and then the other one is quote from number 4 is a quote from Walters and Friedlander from the journal Family Court Review, and it's got the whole article on it. And it basically says it's a shared delusional disorder, and they cite to me twice, okay, as the expert in delusional thought disorders. And so they know it's a shared delusion, and they're citing to me, and yet they're still not assessing for delusional disorders or child abuse. It's just phenomenally bad. So then, starting with 5 and 6, those have to do with the actual hearing and my defense document. So the first one are 2013 emails from Dr. Burnett regarding the DSM-5. And let me talk about those for a second, because the AI identifies those as a smoking gun. Because in 2013, he sent around emails around the publication of the DSM-5, the document that he knows full well that the American Psychiatric Association, he's a psychiatrist, the American Psychiatric Association has entirely rejected the construct of parental alienation as being a real thing. He knows that. And then he also knows in the email, he also states what the DSM-5 diagnoses are: delusional disorder, factitious disorder, and child abuse. So he knows what the DSM-5 diagnoses are, at least since 2013, and actually since 2011 when I talked to him and first encountered him, first email, later exhibit. I told him it's a shared psychotic disorder. It was in the DSM-4, shared delusion. So he's known about that. And it appears he's misdiagnosed it for his entire career. But they had a 20-year head start on me. Okay, they've been in the family court since 1980s. I came in at 2010. So they had already established themselves in their little collective of experts in this fabricated pathology. So those are pretty important because they establish that he knows, and he's intentionally withholding the DSM-5 and misleading parents to believe that he's discovering a new form of pathology and that the APA is rejected. He just won't take no for an answer. The American Psychiatric Association gave him all the information. They said no. And he's a psychiatrist, and he says, well, I know more than the APA does, and so I'm going to continue on anyway. Stop it. No, there's no such thing. Use the DSM-5, and we solve it today. But he won't do that. And then we have Dorsey Pruder, who was an eyewitness at 2 meetings I had with Dr. Burnett. And she's going to be testifying about those meetings and what I was trying to do. Those are 1.04 obligations to informally resolve the ethical violations. So she was there. There was one in Boston around the AFCC conference, and then we were over in Venice, Italy, regarding this other conference. My wife and I took a family vacation. Dorsey was over there doing business, and Burnett was there presenting. So I hosted a dinner at the hotel with Dr. Burnett and his wife, me and my wife, Dorsey, and a parent advocate, trying to encourage Dr. Burnett to work together. Let's shift over to the DSM-5. Let's focus on protecting children rather than turf battles over who's the expert and this made-up pathology label stuff. He was absolutely, nope. He's going to continue on with parental alienation, no matter what happens off of that. That's irrelevant. The consequences of doing that are irrelevant to him. So she'll be testifying about that. And then we have an essay from 2015 within the parental alienation study group after I published my book that Burnett and Ray published and produced an article, and then I responded to it. Basically, they were saying that it's my Foundation's book. Around here now. Foundations is basically parental alienation using different words, and that's what they said about the APA and the DSM-5. Oh, it's in there in spirit. They just won't accept. No, it's not. No, Foundations is using family systems and personality and attachment to describe it. It's not parental alienation using different words. And so that's that exchange. And then in 2017, that's the AFCC conference in Boston, went back to present there. And I had, I think, 7 designated slides within this whole presentation. I explained what the pathology was, and in 7 slides, I told them explicitly about the 2.01 competence violations. And so those are those 7 slides. I am doing the right thing. I'm notifying the institutional authorities regarding the ethical violations that are going on. Nothing happens. There is no motivation to resolve the ethical issues. There's no motivation to resolve the child abuse or spousal abuse. There's no motivation. Why? Follow the money. Follow the money. The moment we apply the DSM-5, we don't need custody evaluations. We need clinical diagnostic assessments, 4 to 6 weeks, so their whole industry disappears. The moment we apply the DSM-5, we don't need made-up pathologies because it's in the DSM-5, so the whole industry of fabricated pathology disappears. And so there's no motivation because everybody's getting their needs met rather than taking care of the families and children and the parents in the family courts. And another feature about this is the degraded quality of mental health services being offered to the court. That the court isn't getting a diagnostic assessment at a professional level with the DSM-5. It's not getting answers about which parent's abusing the child. When a child's rejecting a parent, the only cause of that is child abuse by one parent or the other. So we should be returning child abuse diagnoses every single time, one way or the other. If it's not a true child abuse by the targeted parent, it's a false, factitious disorder imposed on the child, the shared delusion. And so it's one way or the other. And so that gives you an indication of how many victims are out there. Since 40 years, we should have had a child abuse diagnosis every single time a child's rejecting a parent, and we've had none. My goodness gracious. Okay, so that's I'm doing what I'm supposed to be doing, but the institutions are not responding. Then the next one has to do with another institutional capture, which is a petition to the APA. And with the Exhibit 9 there, I wrote a petition to the APA signed by 19,000 parents. I asked for 10,000 parents and I would hand delivered. I had 10,000 parents in 2 days. So then by the time we went back in June, there was 19,000 parents on it. 2 parent advocates, myself, we went back there, group of parents, Dorsey was there, and we went back there and we hand delivered the petition to the APA He said, give this to the ethics committee. Haven't heard a peep from them, not a response. In 2018, 7 years, they such contempt for the parents in the family courts. They don't even give them a response, because the moment they respond, it's all true. And so the only way to not address the issues of the ethical violations and the child abuse is simply to ignore any effort to get them to address the issues. The moment it happens, boom, everything's solved. So that's a petition to the APA, and I think that's potentially evidence in a class action. A psychologist, not an attorney. But that's the only way to get protection for these families, I think. If the regulatory agencies of the licensing boards and the APA are not going to protect their citizens, then we have to take it different routes. We have to get up to the state legislators or into the legal system to get protections for a special population, a vulnerable population. Then number 10 is the standard 1.04 letter sent to 6 AFCC instructors and their response to the 1.04 letter. So in January, I took a course from the AFCC given by 6 prominent forensics custody evaluators, advanced issues in family law, and it activated my 1.04 obligations. I believe there may have been ethical violations by another psychologist. So I contacted the 6 instructors with a standard letter, 1.04 standard, and I explained the concerns. And then they responded with basically a collective 1-page response. They said, no. They didn't address any of the issues. They said, no. Okay, so that activated my 1.05 obligations because it wasn't resolved in that case. And the issue is, this isn't about parental alienation, it's about child abuse. And so there's substantial harm being caused by these ethical violations. To not be competent, 2.01, to not apply the knowledge, 2.04, and the bases of assessment, creates substantial harm because we're not diagnosing child abuse. So that activates 1.05, and that it's mandatory. I got to do things. And it says, notify institutional authorities, notify a National Committee on Professional Ethics, and notify the licensing boards. That's what standard 1.05 says. So pursuant to that, I notified the APA Ethics Committee. That's Exhibit 12. And then the Exhibit 13 is the APA Ethics Committee response. They said basically they do not review complaints until after the licensing boards review them. So basically I'm being instructed to file licensing board complaints. So Exhibit 14 is my notification to the AFCC Board of Directors. That's the appropriate institutional authority. And then because I was instructed by the APA Ethics Committee to file licensing board complaints, I filed licensing board complaints against the 6 psychologists, 2 of whom are in California. And so those are the complaints there. And on the first page of the complaint, I think that's the most very relevant issue. If you look at the questions they ask, they say, is this a custody case? So obviously they're segregating out custody from their normal review process. They say, do you have sole custody? Do you have custody? Because do you have release of information? If you don't get release from both parents and sometimes the court, they can't review it. And then they also say, is this court ordered? Which is that quasi-judicial immunity. So they just won't review any mental health services that are court ordered. They give it quasi-judicial immunity for this experiment. And that's how they escaped IRB review. Over in the healthcare sector, when we do any sort of experiments through academia or clinical services, then we have to get IRB review, Institutional Review Board. Children's Hospital of Los Angeles, for example, has a lot of experiments, medical experiments, and they have their own in-house IRB review board authorized by OPRR, OHRP. And so they would get their protocols approved through them. But what the forensic custody evaluators did was go into the legal system and get court orders for their experiment. And there's no mechanism in the legal system for reviewing experiments. So they did this little shell game to avoid IRB review. And that's why we need to go back and get one. And the moment you get one, no IRB review board would approve a forensic custody evaluation approach. So with, you get special protections on the people. You could not withhold clinical diagnostic treatment. That would just be bad. So then 17 is my domains of competence and vita. And what that shows is that I'm not only competent, I'm expert level in a number of domains. And that when I entered the family courts in around 2010 period, as I'm learning about what's happening over here, because had one client brought me in and I go, oh my gosh, what's going on in the systems over here? Once I recognize this is child abuse, which is immediately, this is child abuse, factitious disorder, shared delusional disorder, and child, either one of those, child abuse. So once I recognize the child abuse and spousal abuse, this is my pathology. Child abuse and trauma and complex trauma and personality disorders, that's a transgenerational trauma thing. And so based on my expertise, I could not abandon these families because I am in a special position as being like senior staff who has all this expertise. I can't walk away because if I walk away, there's nobody there. And so I have obligations to stay with the children and family, which is what I would do for 15 years. We're coming up on Christmas here. I've gone through 15 years of doing Mother's Day talks and Christmas talks to these parents and stuff, and Facebook posts, and just being with them while their children are abused. One of the nasty things about the spousal abuse is that these parents are forced to watch as their beloved children are twisted into these people that are just unrecognizable, mean, nasty, hostile, terrified. That's their beloved, and they have to watch it happen. That's just so brutal to these poor parents. And then, let's see. Then we have the response. Okay, we've already done this page. Oh, the institutional capture and betrayal. So that's an exhibit about Stigler and institutional regulatory capture, and Freud, institutional betrayal, which is the context. And where that becomes relevant is on standard 1.05 that requires mandatory that when there's substantial harm and it's not properly resolved by informal notification or isn't, I'm trying to informally notify people and things, when it's not resolved in that way, I must take further action. It's not optional. It doesn't say consider taking further. No, it says psychologists take further action. That's required, appropriate to the situation. What is appropriate to this situation of institutional capture, where the institutions are not accepting discharge, where the institutions are basically condoning the unethical practices and experiments on human subjects? What's appropriate for that? Okay, and that's where the institutional capture and betrayal become relevant to the situation. That's the situation I'm in when I'm trying to fulfill my ethical obligations. And then we have standard Exhibit 19, which is my 2011 PASG email, membership email to Dr. Burnett. And so this is the first encounter I had with Dr. Burnett directly. I kind of researched everything out, and he's created this new parental alienation study group, and he's supposedly the allies of parents and, caring about things. So I joined the PAS study group. I'm the new kid on the block. I need to build standing within the family courts for a while. So I'm starting to enter the system. I'm not going into custody. I'm not doing custody evaluations because that's a bad thing to do. So I stayed clinical psychology the entire time, so I wouldn't be corrupted by the system. But I joined the PASG, and in that email, I tell Bill, Dr. Burnett, that it's a shared psychotic disorder, 297.3, a shared delusional disorder. You can look it up in the DSM-4 TR. That's exactly the pathology. And so Gardner and all these people have been fighting for 40 years or since 1980s for this new form of pathology. And they say, it's not in the DSM. Yes, it is. It's a shared psychotic disorder if anybody would ever apply the DSM. But the forensic custody, my psychologists don't apply it because they're off experimenting. And the self-proclaimed experts in parental alienation just, I guess, missed the diagnosis entirely because they're not applying the DSM-5, which is kind of embarrassing, if you're a psychiatrist and you don't miss a diagnosis. And so then we have that email. And then we have my first blog post in 2014. So as I was getting standing in the family courts in 2014, I opened a blog. And so my first two blog posts, one was about that we need to stop this fabricated pathology of parental alienation. And then I described what the pathology is using the DSM-5. 2014, it was the DSM-4 TR, which was the shared psychotic disorder. Then in 2020, the Exhibit 21 is that in 2011, in addition to discharge my duty to protect, I immediately went to YouTube and told everybody what the pathology is. So I have a whole series of Pasadena series I filmed in my Pasadena office to discharge my duty to protect because I knew it was going to take me some time to develop standing in the family courts as a new kid. And I didn't want to delay having the information available to parents and their attorneys and the courts and everybody. So I just filled that. And so that exhibit is an AI summary of each of the videos that I did. And you can go watch them on YouTube. And then Exhibit 22 is a 2011 essay. So that goes back to the moment I hit the family courts and began to become active. I wrote an essay around boundaries of competence and what the DSM-4 TR diagnosis is, shared psychotic disorder. So you can read that. This has been known for 15 years, but nobody cares. Nobody cares about the ethical violations, the competence violations. Nobody cares of what the actual pathology is. And the moment you do, the very instant you apply the DSM-5, everything in the family courts gets solved. Because the moment you diagnose a child abuse, you can treat the child abuse. But if you don't diagnose the child abuse, then you leave the child with an abusive parent and you're trying to treat it and you're going to rip the child apart. No treatment is going to be effective for physical abuse if we leave the kid with a physically abusive parent. No treatment for sex abuse is going to be effective if we leave the child with a pedophile, sexually abusing parent. No treatment for psychological abuse is going to be effective if we leave the child with the psychologically abusive parent. We need that period of protective separation from the child in order to recover them, and then we restore with the abusive parent with enough safeguards to ensure that the abuse doesn't resume. So that's what we do with child abuse. So is it child abuse? People, look, is it a shared delusion? Is it the fact? They won't look. They say no. You say, is this? And they say, I'm not going to tell you. That's what they say. I'm not going to tell you whether it's child abuse, if there's a delusion or not. I'm not going to tell you. That's phenomenal to me. That never happens in healthcare. You go into your physician, you say, "Doctor, what's wrong with me?" He says, "I'm not going to tell you." Wait a minute, you're the doctor. I'm coming to you to diagnose my problem. What do I have, cancer? The problem? I'm not going to say. That's just insane. The whole system. That's the experiment that's being conducted. It's just so bad. And so I'm telling people 2011, and this is all showing a pattern that begin. This is not a defense to these charges. This is reality. I've been living this for 15 years. Standard 1.05 that requires I take further actions appropriate to the situation. And then what's appropriate to this situation? Here's all the documentation about what the situation is. So then the 2018, I published a blog about my ethical obligations. So in 2018, I published a blog saying I have standard 1.05, the 1.04 and 1.05 obligations to do something, and I'm encountering violations 2.01, 2.04, 9.01, and 3.04. And now Walters and Friedlander found my article that I posted on and I actually submitted that to a journal controlled by the PAS supposed experts, and they turned it down because I didn't cite the Gardner. And so I posted it instead, and that's the one for Walters and Friedlander found. So they know, and they follow my blogs. I mean, come on, you guys know I've got these obligations. I'm telling you what the ethical violations are, and that was 7 years ago. And then, so this isn't something I'm constructing for this defense. This is actual reality. Then in 2019, I published a blog on the ethical violations in forensic psychology. So I'm telling everybody what the ethical violations are. No one cares. Why doesn't the APA come in and stop the ethical violations? Why doesn't the licensing board stop the ethical violations? No one cares. Isolate the victim from reporting and rescue. That's part of the pathology. And the treatment for that is to break that isolation, is to get that little sexually abused child to report to somebody, their teacher or their grandparent or somebody, your coach, their parent. Get the child to report, break that isolation going on. Get that spousal abuse victim, get them to report to the mental health person, then we can get them into a shelter and protection. We need to break the isolation of abuse pathology. That's the treatment. And guess what? I know exactly what the treatment is because that's my field, child abuse and trauma. And so nobody's listening to the expert in the domain. And we have all these incompetent people just making stuff up. And standard 2.01c says if you're not competent in the domain, consult with somebody who is. But do they do that? No, because they just entirely disregard the APA ethics code, which is mandatory. It is so phenomenally bad in the family courts. So associated with that course, the AFC sponsored course, when I have to file then with notify the APA ethics committee, the board of directors for the AFCC, and file licensing board complaints, mandatory, obligated. The APA ethics committee says file licensing board complaints. So I went and used the AI because I like AI. It provides nice neutral analysis. It's not biased or anything. It doesn't care about anything. So I trained the ChatGPT-4 at the time to review VITA. And so you can go through, and this is a chat dialogue about that analysis. So you can see how I trained it in the analysis of VITA. You can upload it to your AI if you want. And then we went through, I said, grab the VITA of so-and-so, and we'd go on, grab the publicly available VITA. And I said, are they competent in attachment and delusional thought disorders, and do they do a lot of custody evaluations? That's your pattern. They're not competent in attachment, they're not competent in delusional thought disorders, and they're doing a high volume of forensic custody evaluations. That's your pattern. And so, sure enough, all 6 show exactly the same pattern. No competence in attachment, no competence in delusional thought disorders, and a high volume of forensic custody evaluations. And then I added 2 more. 2 of the other major leaders, Dr. Stahl and Simon, who literally wrote the book on how to conduct this experimental approach of forensic custody evaluations. Guess what? They show exactly the same pattern. And so if all the licensing boards, all 50 states, request the VITAs for all your forensic custody evaluators, get them off the court list. Look around websites or something, but get them off the court list. And then do this. You don't have to use mine. You can use mine. You can say, do this, but you can get your own AI. ChatGPT 5.2 is out now, and Gemini 3. I like Gemini 3. So train your AI to look for competence based on education, training, and experience, not their opinion piece, article writing, and not their presentations given. Those aren't education, training, and experience. So you focus on what's relevant, and you can look. Are they competent? Just to get a sense. Just look. And you're responsible for protecting the citizens of your state. Find out what's going on in terms of competence in the family courts. So that's what Exhibit 25 is. Exhibit 26 is I had a consultation request from a Malaysia court reform group regarding Jack's Law. And so because I'm using AI right now, I like AI, I took it right into ChatGPT 5 and I said, hey, Max, when I call my ChatGPT 5, I said, hey, it's easier to type than ChatGPT 5 every time. And, hey, Max, I got this consultation request. What do you think? And you can see this. This is a chat dialogue about that. And it said, oh, this is bad. Oh, there's so many problems with this because they're using parental alienation. They're even citing the Burnett on this. And so they're using parental alienation, trying to criminalize parental alienation. And the ChatGPT said, oh, this is so bad. And I said, what happens if we were to switch that and apply the DSM-5? And the ChatGPT said, wow, everything changes. Now everything's solved. And here's why, and here's how, and so we went through that for a couple of prompts, and then I said, so provide them with your recommendations. So he said, here's my recommendation to the Malaysia group about revising the regulations to their legislature. And then it said, do you want a public policy brief? Okay. And so it produced a public policy brief. So on this Malaysia consult, you have what to give your legislators to ask, I need this, please, okay? Because it's right there, and I agree with it. This is what the legislator should look like. And so that's available. And then I took it over to Claude, because that's what I like to do with my AI analysis. I'll do it one with the other and do cross-checking and various things. So I took it over to Claude, and I like Claude, and asked for confirming analysis of the Malaysia consultation. And Claude, the phase 1 is Claude orienting to what's happening in the family court. So I gave him quotes from Stahl and Simon, and I gave him the Blue Ribbon Commission quotes, and we talked about that. And so Claude recognized, oh my God, these custody evaluations, they're so problematic. That's phase 1. And it's all one big chat, but I broke it into 3 kind of topic areas. Then I said, okay, so let's look, because the moment the Malaysia group stopped using parental alienation and switched to the DSM-5, everything was solved, right? And Claude said, yeah, well, absolutely. And I said, so what kind of implications does that have regarding PAS and parental alienation? That's where Claude just went at it and said, oh my God, in the 2013 emails and stuff, the AI calls it intentional harm facilitation. Intentional harm facilitation. I said, is that a legal term? It says no. That's just something it used to describe it. Intentional harm facilitation. If you switch out the harm for what type of harm, it's intentional child abuse facilitation. Whoa. Whoa. And so that number, exhibit number 28, is pretty problematic for these self-proclaimed PAS experts. And it's not me, it's the AI. Go argue with the AI. Upload it to your own AI to discuss it. And then 29 is the final piece where Claude and I talked. And I said, you know what, Claude, I'm looking, this might be a class action. Claude said, I'm not an attorney, you're an AI, but from where I sit, I'm thinking. And Claude said, yeah, from an AI perspective, it looks like there's grounds, at least for consideration, and here's all the pros and cons of that. And so it got a nice analysis on that. But I really don't care about class action. I care about the now adult children and their parents. We need, then the institutional betrayal trauma. We need to get treatment out into them. And that treatment involves the institutions acknowledging what happened. And so that's where we shifted into talking about the institutional regulatory capture, Stigler, and the institutional betrayal trauma, and what needs to happen with that. And so that's kind of looking forward and going forward on things. So that's Claude 29 off of that. And then 30 is the settlement counter proposal and my discharge of duty to protect. And so here's the 4 things on my discharge of duty to protect: moratorium on custody violations, remediation of competence, AI-assisted VITA review, and then recognition of institutional betrayal trauma with the now adult children and their parents. There are California legislature should get kind of attend to what their licensing boards are doing. They're not, in my view, protecting the citizens of California. They are protecting self-proclaimed experts in pseudoscience that are harming the citizens of California. So I think there's a little bit of inversion on their obligations there. So I would, that's the next phase, is going into the California legislature, and that's where all the documentation, and that's where I'm a whistleblower, so I'm not letting them just suppress that information. I'm making it publicly available so that we can get the proper oversights for child abuse. It's not parental alienation. The moment we introduce that word, it covers it up. We're not talking about parental alienation. We're talking about child abuse and spousal abuse. So there's 2 committees, Assembly and House, and there's one for the judiciary that covers the law, the courts, and the other one, the business practices, that covers oversight of the licensing boards. And up on my my website, on the California legislators page, I've got the links to their website, as well as the names of who's on the various committees. Some of them overlap, so you see overlapping names. They serve on both committees, the judiciary and the business one. So that's available for people. And if you're not in California, it's your licensing boards too. Okay, it's all 50 states. So get your legislative aid to pay attention to what's going on over here, because your state's the next. Pennsylvania, I presented to Pennsylvania, and they were kind of active for a while. So get your Pennsylvania legislators to pay attention out here. Illinois, Florida, Texas, Arizona, New Hampshire, all over the place. All of them. Get them paying attention. And so with that, I am going to head off to my Sunday here and get some work done and headed off to church. I like church on Sundays. So with that, I'm going to head on off out of here, and I'm giving daily updates. At this point, I've presented the information. I'm not interested in trying this in the public, but so I'm just being transparent on what's out there, because I have still carry 1.05 for ethical violations. But more important to me is the clinical duty to protect. This is child abuse. We have an identifiable victim in imminent danger of child abuse and spousal abuse. And so we need to take steps to, at least, at the very minimum, get a diagnostic assessment for child abuse to the differential diagnosis appropriate for each parent, at the minimum. But that's being denied to parents in the family courts. So I get these consults, and I can tell you what to do about the family courts, what kind of court orders to get, but you're still going to need mental health services, and there are none. And so that's kind of the situation for all the parents everywhere. And I'm tired of no solution. I'm tired of nobody caring. If there was a pinky little bit of motivation, it's solved immediately. And it could have been solved 15 years ago when I first entered. It could have been solved in the 1980s if Gardner hadn't gone off and made a new pathology, and if the psychologists had stayed in their domain of diagnosis and treatment. But because both of those hit at the same time, the psychologists left clinical practice and became quasi-judicial advisors on custody instead of diagnosing and treating. At the same time, Gardner left established knowledge and gave himself permission to make up new forms of pathology rather than apply the DSM at the time, which it was in the DSM, shared psychotic disorder. If Gardner, a psychiatrist, had simply applied the DSM-5, we could have avoided this whole thing. But then he takes everybody down the trail of fabricated pathology, and because this is isolated and institutional capture, it's just resulted in 40 years of trauma. So with that, my daily updates will mostly probably be just about my mental health and well-being going forward as I get ready for things and where I potentially see things going in terms of the family courts. Because again, I'm looking at estimate a couple years left before I hit that doorway and I'm out of here. And I may live to 90, but hope not. But but my dad, both my brothers, male, so I've already had one stroke, and that's what they all died from. So I'm still carrying my duty to protect still. And so I'm trying to get the information out there in institutional capture so people can solve this as soon as anybody cares, as soon as there's at least some motivation. It's solved immediately. So with that, take care, everybody. Merry Christmas. I'll be in touch around Christmas as well. And so we'll talk to you later. Bye-bye.